You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Bill, welcome.
Good day.
All right. So really interesting case here, Bill. The bankruptcy judge ruled that Stockton, California, the city, is eligible for municipal bankruptcy in Chapter 9, even though the city hadn't yet negotiated with the California Public Employee Pension System for a reduction in their pension liabilities. This sounds like a major win for the city and a defeat for bondholders. Is that an accurate way to look at this?
Good question. This very well could end up being a situation in which the city won the battle, but will lose the war. Here's the deal. In California, at least, you got to negotiate before bankruptcy in good faith with your creditors. And bondholders alleged that that hadn't taken place because the city had not even tried to negotiate a haircut on pension liabilities. Bondholders said that's ipso facto bad faith. The bankruptcy judge disagreed. He said, in his oral opinion, delivered from the bench, took him about 2 hours, that there was no, let's say, written in stone requirement that they had to negotiate with the CalPERS people, because frankly, that really would have been impossible, at least before bankruptcy. The judge did, however, after saying that they are properly in Chapter 11, go on to say it is possible he might not be able to confirm a Chapter 9 plan because of a little question called unfair discrimination. Keep in mind that arguably, at least, bondholders and the CalPERS pension folks are on the same level of unsecured creditors. And the bondholders are saying, no, you cannot impose a haircut on us while the pension debt goes fully paid. Now, by the way, Lee, this, in a way, is kind of ironic. Up until now, municipalities have been scared to death of bondholders, and so they have been paying bonds in full, even though principally municipal workers take all of the hickey. Now, of course, the shoe is on the other foot, and the bondholders are facing a hickey, and they're saying, no, this isn't right. You have to give a hickey to the workers as well.
Everyone gets a hickey.
Well, that's exactly right. That may be what it comes down to. I don't know how this is going to come down eventually. Could have to go all the way to the U.S. Supreme Court for all I know. However, there is a possibility that in a worst case, there could be a rule established out in California that if you do not haircut pensions, you cannot go through Chapter 9 successfully. Stand by. This pretends to be a biggie. Yeah. But let me make a guess, because both sides have so much to lose, that's when you get settlements.
Something to keep our eye on. Bill, you also wrote several stories on a company named Eurofresh and how unsecured creditors argued that Chapter 11 can't be used exclusively for the benefit of secured creditors. How did the case end up at the end of the day?
Very interesting. Not a bad result, but the question is, where do we go from here? Eurofresh is a giant greenhouse, and when I say giant, I mean giant. It's more than 300 acres under glass, biggest in the country, grows tomatoes. Before bankruptcy, a competitor named NatureSweet bought the secured debt and was going to basically swap the secured debt for ownership, but in the process, all of the Chapter 11 expenses and priority claims would not have been paid. The official creditors committee, represented by a law firm from New Jersey, of all things, appeared out in the Arizona court and said, no, you can't do it. This is a misuse of Chapter 11. They objected to everything they could think of, and here's how it came down. They were able to negotiate a deal where the purchaser is going to, in essence, pay all of the priority claims that bankruptcy requires to be paid in full. They did not, however, succeed in getting any distribution for unsecured creditors. This is an issue that is actually being examined by the commission that studies bankruptcy law every number of years. And that question is, can you have these quickie Chapter 11 sales that are really pretty much exclusively for the benefit of secured lenders, especially when people who provide goods and services in the Chapter 11 case sustain a loss. Methinks we are not at the end of this tale, and I see a tendency over time where bankruptcy judges are requiring buyers to contribute more and more for people lower down the priority scale.
We also have news on the Milwaukee Archdiocese bankruptcy. It's been in Chapter 11 for almost 2 years now. And Bill, the judge in that case is making news because he cut off lawyers' fees. How'd that happen? I always thought lawyers are supposed to get paid first at the end of the day, right?
Yeah, that's what everybody thinks. But the funny thing is, it hasn't always been that way. Lee, back when you were in diapers, bankruptcy lawyers didn't get paid every month. In fact, they very often didn't get paid until the case was over, and that could have been years later. Lawyers didn't like it much. They complained bitterly, and over years it changed. Where now pretty much all around the country, lawyers, at least in the larger cases, are getting paid every month. Out in the Milwaukee Archdiocese case, and of course in Milwaukee, the Archdiocese suddenly came to the realization they had paid something like $9 million in counsel fees, and they were just about to run fresh out of cash.
Wow.
So they ran off to the bankruptcy judge with their problems, and guess what? The bankruptcy judge shut off the fees for both the Archdiocese as well as for the creditors committee, which is in essence representing victims of clergy sexual abuse. What really I can't wait to see, Lee, is how quickly this brings a compromise or conclusion to the whole case. Because when the lawyers are not being paid and may not be paid until it's over, that gives you a little bit of an incentive to get the case over with and get a settlement.
Sure, it probably made for a very interesting hearing, I would imagine. And finally, on the advance sheets, Bill, Judge Richard Posner, your favorite judge on the 7th Circuit Court of Appeals in Chicago, wrote another gem of a decision. Tell us about it.
Well, I got to say, Frank Easterbrook is right up there in terms of my favorites among all of the circuit judges, but be that as it may, this is a case about labor law and bankruptcy. And the question is, can you, in essence, sell an asset in bankruptcy free of labor law claims? Here is the deal, as Judge Easterbrook pointed out in his wonderful opinion. The case, by the way, is called Teed, that's T-E-E-D, versus Thomas and Betts Power Solutions. He recited how outside of bankruptcy, the presumption in federal law is that a purchaser, even of assets, is a successor who remains liable for labor law claims that arose when the predecessor owned the business. The question is, does bankruptcy change that equation? Because as we all know, bankruptcy allows principally, and this is most important in bankruptcy law, for the sale of assets free and clear of all claims. So the question is, can you sell in bankruptcy free of labor claims? Well, Easterbrook wrote an opinion, Judge Posner wrote an opinion that was basically all over the place. It really came down to his simple statement that he could really find no particular reason in this case not to make the purchaser liable for monetary violations of labor law. This, Lee, is a real, I think, breakthrough having to do with labor. Now, we have seen cases like Hostess in particular, where there were and continue to be major disagreements about the extent to which buyers of the business are bound by former labor contracts or Lord knows what. I do believe that this decision by Judge Posner is going to open up this entire area for discussion. And just because Posner is one of the most influential judges in our country, and this was a very wide-ranging decision, I think we're going to see some really interesting law made in this area in the next few years. And it may well be that this opinion at the end of the day is good news for union workers.
All right, let's leave it there for now. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.